everybody, and welcome to our most recent webinar instalment. I'm joined today by Louise Plant, and we're going to be looking at the updated guidance on getting employees back to the workplace, be looking at how employers make the decision to get employees back and what they need to do. So for those of you that have watched our previous webinars, some of this will be a bit of a refresher for you. For some of those that you haven't, then hopefully all the information we provided is informative and helpful for you. I'm also going to be chatting about a few employment considerations in terms of getting employees back, and also just providing you with a little bit of an update in terms of what's going on with employment. So I'll be chatting a little bit about kind of holidays and quarantine, chatting a little bit about the coronavirus bonus scheme that's been introduced. So we'll just have a little bit of a roundup, make sure you're up to date with what's going on. And as always, if you have any questions as we go through the webinar, then please do type them and post them and we will answer them. And of course, as with our previous webinar, we're also going to open this up to a form of legal surgery towards the end. So you can ask any questions of us. Please keep them health and safety and employment related, but ask any questions of us, whether it's related to this topic or not, and we'll do our best to answer them. So just moving on to the agenda. So as I said, we are going to, first of all, Louise is going to be looking at updated guidance for employers about getting staff back to the workplace, and I'm going to be chatting about some employment topics. So without further ado, I will pass over to Louise, who will chat about the health and safety part of things.
Thank you. So what's going on in terms of the return to the workplace and what are the government now saying? Well, the position was up until the 1st of August. The government was saying if you can still work from home, then continue to do so. And if you can't work from home, then you can return to the workplace, but employers need to put in place additional COVID-19 safe systems of work. And I'll go on later in this talk to talk about what those safe systems are and what employers need to do. So what's changed though? Well, as of the 1st of August 2020, employers have more discretion now to make the decision with regards to how best and safely their staff can continue to work. The government are trying to get people back into the workplace, back into the economy, and trying to get businesses up and running again after what's happened over the last 5 months. So they've kind of, to some extent, passed the buck to employers, which isn't an easy thing to do. Employers now have a huge task to decide what's best for their business. And that is very business related. There is no hard and fast rule. There is no right or wrong answer. It's very much up to employers to think about what's best for their business, what's best for their employees. And that could mean actually the staff continue to work from home, or it could mean that if the workplace is now COVID secure, then employees can start to come back to the workplace. Some workplaces have started to have a skeleton staff in any event, and you want to think about getting more people back into the workplace, or as a whole, you want to get your entire workplace back into the business and back to work in a more normal situation. But as I said, that's very much dependent upon the business. So what are employers going to be thinking about in terms of making the decision as to whether or not they want to bring more or their whole staff back to work? Again, it's very business related. It's very individual. The number of factors that you're thinking about could include the impact that the pandemic has had upon the business itself. Have your staff actually been able to work from home such that now you need to get them back into the workplace because of the type of business that you have, or the roles that those people have just means that, you know what, they can't work from home, or they certainly can't work from home productively. So you want to get your staff back into the workplace itself. The next question is more in terms of the employees themselves. So how effective have those employees been working from home? Now, some employers I know have seen actually productivity's improved because people have been working from home, and other employers have seen a completely different pattern where productivity has effectively gone off a cliff. Not only that, but those employees working from home, they may have personal circumstances at home that has made working from home difficult. So you want to get them back into place. Back into the workplace. I have a 5 and a 7-year-old, and I have to say that now we're in the summer holidays, working from home is not ideal at all. I've started to go back into the workplace a couple of days a week because I literally just can't hear myself think at home. So the personal circumstances of your individual employees may want to be taken into account to get them back into the workplace, to get productivity up and to get the business going better than perhaps it has been over the last 5 months. Also, you need to think about whether it's safe to bring those employees back to the workplace. It is a hard task to get your workplace COVID secure, and I'll talk about that shortly. You need to think about whether the cost or the benefit of getting them back into the workplace is offset about the costs and the amount of resource and what you need to do to make your workplace COVID secure. You may think, actually, all those steps that I've got to take, all those things that I've got to think about, perhaps the cost of doing that just isn't cost effective. It's better to keep my workforce at home because that's an easier situation, or I just can't comply with the government guidance to get my employees back. Your resources may be so stretched that it's just not possible, in which case, if working from home does work for you, it doesn't impact upon your business, then you may just want to keep your staff at home for the time being. And finally, in terms of the employees themselves also, you may have a number of high-risk employees. Now, you may recall that also as of the 1st of August, shielding is effectively being paused, which enables those employees who are higher risk to also come back to the workplace. But just because shielding has paused, it doesn't mean that those employees aren't still higher risks, as in they aren't still either clinically vulnerable or clinically extremely vulnerable. If you have people with underlying health conditions, that means that they are more susceptible and that they may have issues, or they may be more at risk if they do come back into the workplace. And you need to think about them specifically and make sure that they are able to come back, and they're able to come back in a safe manner. So if you have taken the decision that you want to get more of your staff back into the workplace, what do you need to do? What are the steps that you need to go through to make the workplace COVID secure in line with the government guidance? Well, the first position is to undertake that specific COVID-19 risk assessment. Now, you have, I'm sure, risk assessments in place across the board in any event for your business, but you need to undertake a specific COVID-19 risk assessment. And the government have provided guidance in terms of all the areas that you might need to think about in terms of undertaking that risk assessment. It is no mean feat, because effectively what you need to do is to think about how your workplace operates, how people come in and out of the office, how they move around the workplace or the office, the shifts that they're doing, their actual workstations, how contractors are coming in and out of the business, whether there's goods coming in and out. It covers all the different areas that you need to think about in terms of where there might be a heightened risk of the transmission of the virus. So the first step is to look how your business operates, how it works, how it runs, and that again will vary dependent upon the layout, the type of business that you have, your employees, everything about how your office is run. It's very specific to your business. So you undertake that specific COVID-19 risk assessment, and off the back of that, you can then decide what mitigating steps that you can put in place to try and reduce the risk of transmission of the virus to the lowest level practicable. And again, what mitigating steps that you can take will vary from business to business. It will vary depending upon your resources, the way that the place is laid out, what you can actually do. And the guidance itself does give quite a few suggestions in terms of how you can mitigate that risk. There is plenty of information there, and you kind of need to figure out what your business can do with the resources that you've got, with the people that you've got, and what's available to you and what's best for your business. So the starting point, you do your risk assessment, you look at what steps you can put in place. And then the next step, before you actually put those practices and procedures in place, is to communicate that risk assessment to your employees. Now, I would say that there are very few people that have been untouched in terms of how this virus has impacted upon them. Getting people back into the workplace is a difficult situation where you have employees, some of whom will be more anxious than others. The point of the communication from the government's perspective, and it does actually make sense, is that in order for the practices and procedures that you're going to have to put in place, you want to get your employees on board. And the only ones who can really say whether or not that's going to work for your business and your employees are those people. So it's important that you liaise with them and you communicate to them the plans, the practices and procedures that you're proposing to take to make them feel as safe as possible. And they may look at that risk assessment and they may look at the steps and procedures and just think, you know what, that's just not practicable. That's going to make my life so difficult. You know, we just can't do that. It's going to just make working life so much harder. and perhaps even worse. So send that risk assessment out to them, get their comments, get their feedback, and then you can finalise your policies, your practices and procedures before then putting those practices and procedures in place within the workplace before you then get people back to work. Now, once you've done that risk assessment, once you've got to the final stages, you know what practices and procedures you're going to take for your individual business. The next thing you do, if you have over 50 employees, the government expects you to publish that risk assessment on your website. And the point of that is that, in particular, say you have contractors, you have clients coming into your workplace, you have, various other members of the public coming in and out, they can have a look, they can see what's going on. So they can also decide, whether they want to attend or whether they want to take alternative action in terms of coming into your workplace. So as I said, they expect you to publish it on your website. And the other thing that you should be doing also in line with that, when everything is finalised, is you should print off, there's a poster that you should put in the workplace that just says, I've undertaken my risk assessment, we've taken the practices and procedures, and we are COVID secure as far as we can. Remember, the duty as an employer is to take all reasonable steps that are practicable for your business. And again, that will vary from business to business as to what you can and can't do. So after that, what's next? You've got your practice and procedures in place. You've got your employees or your staff back into the workplace. Monitor those practices and procedures. Keep an eye on what's working, what isn't working. You may need to tailor it. You may need to change what you've done. When you actually get people back into the workplace, you can see what's working and what isn't. And again, it's so important to have that dialogue with your employees to make sure they're happy. You want them to come back into the workplace. You want them to feel safe and secure so that anxiety is put to bed and they can just get on with doing their jobs. So it's really important that you keep on top of that. You make sure you take feedback and you respond accordingly. Finally, again, keep on top of the government guidance. It's changing week to week. The updates come daily. If any of you are lucky enough to be getting those daily updates, it's hard to keep on top of them. It's hard to keep track of what is going on. But keep on top of what's happening, and then make sure you implement it within your workplace accordingly. So that's kind of all I've really got to speak at the moment about in terms of the health and safety and the changes to the guidance. To some extent, it makes it more difficult now that the guidance is more pushed to the employers to make the decision in terms of whether or not it's best to get their employees back into the workplace. But if you follow that sort of practical step and procedure, work through the guidance, think about what your business can do, what's appropriate for your business, keep those lines of communication going with your employees, and tailor it accordingly as you go along. Hopefully now more businesses can get up and running and get back to normality as far as they can, and just get on with their businesses now. So that's all I've got to say at the moment. Obviously, if you have any questions on that, if there's anything I can help you with, then please do let me know.
Thanks, Lou. We've got a question that's come through, but I think what we'll do is we'll deal with it at the end because it probably covers both you and me. So moving on to just having a bit of a chat about what's going on in the employment sphere. There was a YouGov survey that came out the other day. It only surveyed 4,000 people or 4,000 workers, but I thought it was quite interesting because it revealed that only a third of them believe they'll not be returning to the workplace until 2021, if at all. A quarter said that they expect to be returning at some point in 2021. 8% expect to be continuing to work from home indefinitely. 21% of workers surveyed say that they are concerned about the risk of contracting COVID-19 on the commute, which is interesting. 30% remain worried about catching it at work, and 45% simply don't want to commute. So interesting stuff, and obviously some trends going on there. I talked quite a lot during our last webinar about employees returning to work and the employment considerations. So what we're seeing at the moment is that there are a number of employees that are coming back off of furlough. There are some employees who are reluctant to return from furlough. Those that do return, unfortunately, we are seeing some kind of attendance issues or performance issues when I'm talking to my clients, which, in the context of there's obviously lots in the news every day with regards to redundancies and restructures. There is a kind of some frustration on part of clients saying that, we are able to bring these employees back, but they are reluctant to return. If they do return, we've got attendance issues. And so this all needs managing. And in terms of, reluctance to return, and this is what I talked about quite a lot last time, and what I talk about a lot with our clients, is that, the first question if an employee says, I don't want to return, is, we've got to ask them why. We've got to point them to the risk assessment that we've carried out. We need to try and alleviate the concerns that they're raising. If they can continue to work from home and you think that, this doesn't affect their productivity levels, then, probably, in light of, COVID still being around and health and safety considerations, it's probably best, to continue to allow them to work from home. If they can't work from home and you need them in the workplace, or you want them in the workplace because there is an effect on productivity levels, and employees are saying, no, I don't want to return, then we then get to a sticky issue. And it's at that point, if the employee is starting to raise genuine health and safety concerns about returning to work, we need to be careful, because a knee-jerk reaction of, well, this is a reasonable management instruction, and if you don't comply, well, disciplinary and unauthorised absence, does lend itself to risks. It lends itself to risks in terms of automatic unfair dismissal claims if the employees raise genuine health and safety concerns, and also in particular if an employee is saying that they believe returning to work would put them in serious and imminent danger, potentially because perhaps of the personal circumstances, then again, they have additional protections in relation to automatic unfair dismissal, and they don't need any qualifying service to do that. So my advice has always been consistently through to ask the employee what their concerns are, see if we can alleviate the concerns. Because it's important to understand the concerns to then be able to make the decision of, okay, is this a genuine concern, or is this a concern that isn't genuine? And actually, we do need to push ahead, and we do need to send out a message that, the workplace is safe, and therefore we do expect employees to return to work. So moving on from that, and I think, our previous webinar are all recorded. So if you did want more detail on any of that, then of course you can ask questions now, but of course you can go and contact Amy Ellis, and she can provide you with a recording. Other things that are going on, I see that the Department of Work and Pensions has published new guidance providing information and support for employers that need to make redundancies in response to COVID-19. They've produced a redundancy fact sheet for employers, and also outline support that employers can give to employees who are being made redundant, and include some links to useful information such as ACAS and Insolvency Service. And there's also now an updated HR1 form. So this is the form that you need to complete and send to the Insolvency Service if you're looking to propose, if you're proposing to dismiss as redundant 20 or more employees within an establishment within a 30-day period. I've had a look at the updated form. I haven't done a comparison from one form to the other form, but from a quick initial glance, it looks very similar to the original form. And I always do think that form is an odd form, but there we go. But what it does do is it does confirm that if we're furloughing staff and we're not contemplating 20 or more dismissals in a single establishment, just because we've got a large number of staff on furlough, there isn't a requirement to carry out formal consultation or inform the Secretary of State. It's only if you've actually got a proposal to dismiss 20 or more employees at one establishment. So we have that. We also have HMRC now publishing a policy paper on the job retention bonus scheme. So for those of you who listen to the Chancellor, you'll be aware of this job retention bonus scheme. So it confirms that it's a taxable one-off payment for £1,000 for every employee who an employer previously claimed for non-fraudulently, it adds. So you've claimed for non-fraudulently under the coronavirus job retention scheme, and who remains continuously employed until 31st of January 2021. All employers are eligible. There aren't particular sectors or thresholds in terms of turnover for employers. All employers are eligible. So if you furloughed staff, you bring them back, and those staff remain with you till the 31st of January, you can apply for this bonus. However, they must be continuously employed from the most recent CJS furlough claims to the 31st of January, and they must be paid at least £520 a month on average between the 1st of November and the 31st of January. And they also must not be serving notice that started before the 1st of February. So they can't be under a period of statutory or contractual notice as of the 31st of January. More details on that scheme are due at the end of September. But at the moment, it seems relatively straightforward, albeit we'll query how many employers will access it. And certainly some of the big name brands are saying, no, we're not going to access the scheme. So we will see what the take up is on that. That'll be quite interesting. The other thing I wanted to just talk about this morning was the wonderful topic of overseas travel and quarantine, because we're having a few queries in on that. And of course, every day there seems to be in the news, oh, this country could be on the quarantine list. And of course, for employers who may, who are busy or indeed have got staff on furlough, so those that are remaining are busy, this quarantine is essentially a massive disruption because it tags on another 2 weeks of absence on top of an employee's holiday. So it's becoming an increasing issue. And the question we sometimes get asked is, can an employer restrict employees' travel during non-working travel time? So in some circumstances or in other circumstances, you could think, well, actually, could perhaps employers consider instructing employees not to travel to areas where the government advises to avoid travel? However, it's questionable whether this could be considered to be a reasonable management instruction, given, in effect, it dictates what an employee is able to do during their leisure time, okay, rather than, of course, an instruction as to how to perform your job. A more practical step may be just to consider advising the workforce that anyone who does travel overseas and is subject to a 14-day quarantine, we're advising them what would happen. So are we going to potentially say to them, well, you won't be eligible for contractual pay, including sick pay? But again, I'll talk about pay in a second, because that is an issue, because potentially we could be breaching the contract if we just say, no, not entitled to any pay. I'll explain why in a moment. We could have a policy that says that employees who travel overseas will need to use annual leave to cover any period of quarantine. And on the basis that any such absence would otherwise be considered to be unauthorised. And that may actually just do the trick in discouraging employees to take overseas trips, or particularly to those areas where we know that there is a quarantine. If we seek to impose travel restrictions, as I mentioned, and then we look to discipline employees, what are the risks there? Well, I guess the risk is that if we're trying to dictate what employees can and can't do during their leisure time, as I said before, query whether that is actually a reasonable management instruction. And so, a more proportionate response would be to make clear employees' options if they decided to travel to an area with a 14-day quarantine, whether this is using annual leave or unpaid leave and such forth. So my advice there is that if this is something you're concerned about, to formulate a policy to make it clear from the outset what would happen if an employee was affected by a quarantine. So in terms of pay, so obviously if an employee goes away on holiday and then they come back and they need to quarantine and they can work from home, then they should continue to work from home and they'll be paid in the usual way. If they can't work from home, then the position is unclear. And I think, the government, and we know it's unclear simply because we have, certain bodies lobbying for the government to provide clarity in this area. Are employees entitled to SSP? Should they be paid contractual full pay by employers? So arguably, an employee who's not able to work, if they're not able to work, they have an implied right to be paid. If they're not able to work, the implied right to be paid doesn't apply. Okay, so it doesn't apply if I'm unable to work, then the implied right for me to be paid doesn't apply. However, it may be arguable that as it's a legal requirement for them to self-isolate, their ability to work isn't affected. And there's a case of North West Anglia NHS Foundation Trust and Greg. And this was a Court of Appeal case, and it held that if an employee is ready and willing, and the inability to work is as a result of a third-party decision or external constraint, then any deduction from wages may be unlawful depending on the circumstances. So an involuntary inability to work, or something resulting from an unavoidable impediment, as they described it, may render deduction from pay unlawful. However, this case was concerned with pay during suspension, and so it's unclear, as with cases often are, as to how far this principle may stretch. However, it is conceivable that an employee who's faced with a period of 2 weeks unpaid leave could argue that, well, this is a government restriction. My inability to work is involuntary. It's imposed on me. Government, is a third party here, and therefore I'm entitled to pay. However, on the flip side, if an overseas trip is booked in full knowledge, such as if you're going to, France next week, in full knowledge that when you come back, you've got to self-isolate for 2 weeks, then I think it'd be very difficult for an employee to subsequently argue that their inability to work has been caused by an extrinsic factor outside of their control, because of course they went abroad fully knowing that they would need to quarantine for 14 days. So it will depend on the circumstances there. In terms of SSP, it is unclear whether the requirement to self-isolate in these circumstances and quarantine would give rise to SSP entitlement. Because the SSP provisions require that it is known or reasonably suspected that the employee has been infected or has come in contact with COVID-19. And it's a stretch to argue that the mere fact that they've travelled to a country that's got quarantine provisions would amount to a reasonable suspicion that they came in contact with somebody with COVID-19. So it's unlikely that SSP would apply. We then query perhaps, will further regulations be issued? Because of course the SSP regulations have been updated a number of times during this pandemic. Will further regulations be issued to amend the SSP regs to include self-isolation on that basis? But I think, given we've got travel corridors, given that we're a month or so on from the issue with regards to the Spain late notice quarantine, I think if the government was going to amend the SSP regs, personally, I think they would have done them by now already. So I think that's probably unlikely. And I think also where an employee's been on holiday and they voluntarily accepted the risk, then and the requirement to self-isolate, then the government's probably not keen to fund periods of such self-isolation, probably from a policy perspective. And as I said, employees can continue to use their annual leave. Could we request employees or demand employees use annual leave when they come back? Well, probably not going to work in terms of the notice provisions you need to give, because if you want to compel an employee to take annual leave, you have to give them double the amount of notice as to the leave they want to take. So if they're having a 2 weeks quarantine, then you need to give them 4 weeks notice. And also, we then go back to the point where we've been talking about holiday in the context of furlough, especially earlier down on the lockdown, earlier in the lockdown, which is, holiday annual leave. It should be to enable an employee to have a period of rest and relaxation. And of course, if they're confined to their house for 2 weeks, will that really be rest and relaxation to actually properly constitute holiday? So lots of interesting issues around holiday and quarantine. I think my advice really would be to have a think within your organisation as to how you would like to tackle the issue. And if it's a case that you want to start requiring employees to take additional annual leave or make it clear that they won't be paid when they return, to make sure you've got a clear policy in place so that employees are going away in full knowledge that this will be the outcome if they have to quarantine when they return. So that was kind of my brief roundup of what's going on in terms of employment law. There's obviously hours and hours and hours I could talk about, but I thought those are some topics I haven't really touched on before. So shall we move on to some questions, Lou?
Yeah, I think a lot of the questions are for me. So I'll run through them. I'll run through them from the start. The first question relates to when businesses ask people to continue to work from home, should they contribute to employees' bills? And I think you're going to have to take it on a case-by-case basis. If you have a large number of employees requesting that, then I think you're going to have a general policy. I think the upshot is yes, and in particular, if they're asking for you to contribute, then you need to be contributing because they are effectively having to work from home and they're using their personal resources, as you've said. But I think take it on a case-by-case basis, take into account those employees' needs, what they're actually doing. what those bills are. Obviously, you don't want to be in a position where you're paying their entirety of their utility bills, but I think you do need to think about contributing or having a policy to agree a level of contribution in light of the fact that they're working from home. But again, it's going to be a case-by-case, business-by-business basis, and having that interaction with those employees to come to an agreement between you. The next question, if we keep people working from home, are we setting a precedent if we want to bring them back to the workplace later on? I don't think so, simply because this is an unprecedented situation, and we're asking people to work from home because of what's going on, not because of the changing demands of the workplace. This is the guidance. You've decided that perhaps it's safer for your employees to stay at home, in which case you're asking them to do so. If you want to bring them back to the workplace in the future, then you can still do that, in particular if you have concerns about productivity or whether or not those employees are actually able to work from home. So I think the upshot is, no, you're not setting a precedent. You're responding to what the government guidance is and what you're being asked to do as an employer. Do you have a link for the government? Oh, sorry, Vanessa.
Sorry, I was going to, just from the employment law perspective, I would just say I would agree with that. I think, certainly if, the pandemic lessons and, the guidance is very clear that everybody should just go back to work later on, then perhaps we have to think about things like custom and practice. But certainly at the present time, and I think even, in the immediate near future, I just don't think it'll be custom and practice at all because of the issues that are arising.
The next question, do I have a link for the government daily updates? Yes, and I'll send it to you. But I would warn you, you get roughly around 40 to 60 emails a day because they're updating so much as they go along. So I'll happily send you that link, but just be warned that your inbox will be flooded for some time to come. So I'll send that through to you, Roger, afterwards. I think, the next question. What if your employees concerned are linked to their belief that COVID-19 does not exist, potentially resulting in not following the employer risk assessment, not complying with the health and safety measures placed within the office? I think the upshot is, whatever your beliefs, whatever your thoughts on the whole situation, the government and the health and safety executive are asking you as an employer to comply with this guidance. So if you have got employees that are just basically not complying, then to some extent you can call them in and have a chat with them and just explain the fact that if it's the case that their actions are impacting upon your other employees in particular who may be more anxious, it will be the employer's head that is on the block effectively for not complying and not doing something about their employees not complying with that guidance. Whatever your thoughts are, if you don't comply, there is a chance that the health and safety executive could ask you to put in place steps to comply. They could file you with a notice, you could get fined. That's not the employer's fault. You're just doing what you can and what you're being asked to do by the government. And it might be worth just having that conversation with your employees who may sort of think otherwise. As I said, whether or not your views are that this is, reasonable or not, that's what you're being asked to do, and that's your duty as an employer.
Yeah, I would certainly add there that you would certainly be giving a reasonable management instruction for them to comply with the risk assessment. And I think, when you look at health and safety obligations, it's not just, and Lou, correct me if I'm wrong, it's not just the fact that we implement the risk assessment. We have an ongoing duty to make sure it's complied with.
Yeah, absolutely.
And so certainly if an employee is refusing, then that would be potential disciplinary matter. And, if they try and argue, well, and I note the use of belief here in this question, I can just see from the cases that I've read in the past in terms of philosophical belief, whether an employee tries to argue that, well, it's my philosophical belief that COVID-19 doesn't exist, I really don't think that they are going to get anywhere with that argument with the tribunal. The tribunal is not going to believe that a disbelief in COVID-19 can constitute a philosophical belief. I'd put money on that. Not much money, but I'd put a little bit of money on that. So yeah, I think you need to press ahead and you need to make sure that the message is clear. All employees need to comply with the risk assessment.
I think the next question for you, Vanessa.
Oh, is it? Which one's this one?
Where do employers stand on withholding pay?
Okay. So where do employers... Sorry.
Yeah, go on.
I'll read it out if that's okay, then I can try and think of the answer when I read it. Where do employers stand on withholding pay where employees book leisure trips abroad with the knowledge that there is a risk of quarantine measures being introduced whilst they are abroad, but the quarantine measures are introduced during their holiday? A really interesting question, and a really difficult question to answer. I think, there's clearly a distinction to be made between employees who are traveling overseas to a country where they know that there's quarantine versus those that may be in Croatia or Greece at the moment where they've gone away and suddenly may well be imposed quarantine when they come back. I think for me, it comes to your policies and what your clear communication is to your employees. You may take the line that actually, as the government has said, actually, haven't they? All travel is risky. There is no guarantee that any country you go to suddenly isn't going to have quarantine restriction imposed. So you may take the line that actually, if you choose to go abroad, even to a country that doesn't have restrictions, then when you come back, you'll be required to take annual leave or it will be unpaid leave. You may well take that stance, but I think communication at the outset is key on that one. Oh, we've got a tax question. Do you know this? What is the tax position on contributions to people's domestic bills?
Oh, crikey. I don't know the answer to that one. I have to admit, I'd have to have a look at that.
Yeah, that's a tax query, isn't it, really?
Yeah.
Unfortunately, outside of my remit as well.
Yeah, I'm afraid.
We'll have to look into that one.
The next questions for me, you talk about risk assessment for the workplace. For employees who continue to work from home on a longer term basis, can businesses adopt a blanket risk assessment to put the responsibility on the employee? No, in effect, whether or not your employees work from home or not, you still have the same health and safety duty towards them, whether they're in the workplace or whether they're working from home. On saying that, at the moment, it's a bit of a minefield, because if you have an employee that is permanently working from home, the health and safety executive would expect you to take steps to some extent, go into that employee's home and undertake a risk assessment, just as you would for someone actually within the workplace. But at the moment, we're still deemed to be temporarily working from home in light of the pandemic. And that kind of puts the responsibility between the employer and the employee, because you can't expect employers to currently go into people's homes and undertake an actual workplace, an actual risk assessment for their workplace or their workstation. So what they are saying at the moment, and what the advice is at the moment, is that you can have a blanket policy in terms of working from home, but you kind of need to give your employees the tools to undertake that risk assessment themselves, because as an employer, you can't go into their home, or, well, you could, but it would be to get around all your employees to do that is probably too much to ask, and it's not reasonably practicable, which is the threshold or the test that you need to be applying. So what you do need to be doing for your employees is saying, look, this is what you need to think about in terms of risk assessing your own workstation. If you've got any queries, if you've got any problems, or you need assistance in terms of, I don't know, chairs, desks, anything to make your workstation better or to enable them to work properly, then you can deal with those queries then. But there's no blanket, you can't do a policy that puts the responsibility on your employees. Actually, you still have the same duties to those employees working from home as you would do if they were actually in the workplace. So I hope that answers that one. I think the next one's for you, Vanessa.
If we need to make a small number of redundancies post-lockdown, would it be fair to have a conversation with staff with ongoing health issues to offer redundancies prior to putting any other staff at risk, not enforcing redundancy on them, but offering them redundancy first? I can understand why you want to do this. I think it's indicative of an employer who's thinking of the well-being of their employees, both those that are kind of at heightened risk and those that are not and continue to be able to work. My concern with it is that if we approached it in that way, is that we may give inferences to either disability discrimination or age discrimination. If, for example, I say age, if you're going to the older workforce first, because whilst we may say to employees, look, this is just an offer, this doesn't, we're not forcing you to be redundant. it's a bit like the retirement conversation. It's a tricky conversation to have because there will be some employees who are suspicious. Well, why are you just approaching me? You're only approaching me because I've got a disability, or you're only approaching me because I'm aged over 70, for example. My suggested approach for this would just simply be, if you're going to do a redundancy round, is just open it up to voluntary redundancies and open it up to anybody to apply. And therefore, if there are staff who, due to health conditions or potentially their age, they want to take redundancy, then there's a voluntary redundancy for them to consider and to accept. So I would do it that way. Yes, you may well get some employees who are healthier and who want to stay, who volunteer, and that's fine as well, because what we tend to advise clients is, with voluntary redundancies, we always say that it's the employer's final decision. So just because somebody volunteers doesn't mean that we have to accept their voluntary redundancy. So that's how I would approach that one. I believe the next question is for me as well, and I think it's a hard question. So should I pass it to you, Lou? No, I'm joking.
That was not funny.
It starts with somebody being employed on a Swiss contract. I was like, oh, okay. So if someone has been employed on a Swiss contract and couldn't therefore be furloughed, but has agreed to a reduction in pay under a short-term pay / layoff clause, which has been in place since April 2020, who's then given notice of redundancy, do they have to be paid their full contractual notice pay, or can they continue under the agreed short-term pay agreement? A tricky question. I think in order to answer that question with certainty, I would want to see two things. I would like to see the letter that confirms the agreement to reduction in pay, and whether that talks about what would happen on termination. I would also like to see the contract and what that says about notice. The one thing that has crossed my mind is whether you could apply the same rule as what we have with furlough pay, which is that we look at the statutory notice period and we look at the contractual notice period, whereby if the contractual notice period is at least a week longer than the statutory notice period, we can pay the reduced pay throughout notice. However, if the contractual notice period is the same as the statutory, then we would need to pay full pay. So I think I would most probably apply that principle in these circumstances. So if you had an employee whose statutory notice period is 4 weeks, but you had a 2-month notice period and the contract, then you could potentially say, no, your notice pay will be at the reduced rate. However, I will strongly caveat that by saying I would need to see both the contract and the letter. And I see that the follow-up comment to that is that's what I wondered. Contractual notice is 6 months, but statutory is 1 week. So certainly, I think you may want to perhaps initially take, depending on what the letter says when you vary the pay, but you may want to take the initial stance of that, the notice period will be at the reduced rate. But just bear in mind that it may be challenged, and what you would do if it is challenged. We've got a comment on the tax. I think this covers it. A link looks like up to £6 a week with a deduction of tax / NIC, but must only be the additional cost. Is that link? I'm kind of really thinking out loud now, which is dangerous on a webinar. But is that link that money saving expert Martin Lewis talks about? If did you ever watch the COVID-19 updates on a Thursday? No, shaking my head. Because I think employees can directly claim a grant if they've been home working of £6 a week. So I'm not sure whether that's so I don't think that's something the employer pays. That's something the government can pay, I believe. But I think it may need to be supported by the employer. Oh, there we go. Yes, you can claim £6 back either via employer or on behalf of your employer. You can do it. Oh, either via employer on your behalf or employee can do it. There we go. You learned something new.
So I think that's all the questions, unless anyone has anything else. I hope that's been helpful. Again, you can always email either me or Vanessa if you have any further queries or anything that you'd like us to assist with. But I think that's all, unless anyone has anything else.
No, definitely. Thank you so much for engaging with us and for joining us today, because it was a bit of a gamble doing one in the middle of August. But I was pleased to see so many of you watching us for the questions. When you log off, there will be a quick feedback survey. It will literally take you kind of 10 seconds. If you could complete that, that would be fantastic. Thank you very much. And hope to see you all soon. Thank you. Goodbye.